Good evening, and we're about to go into session 4 on our seminar of the United States Constitution. So let's just dive right into our first slide. We're going to complete Article 1 of the Constitution, which is the article that creates the legislative branch of the federal government. As we saw last time, Article 1, Section 8 is perhaps the most critical section of the Constitution. It gives the greatest amount of power. These are the enumerated or express powers of Congress. And last time we highlighted the fact that the war powers belong exclusively to Congress. Article 1, Section 8, clauses 10 through 17 talk about the war powers that are expressly and exclusively given to Congress. So I'd like you to keep those in mind when we get to talking about Article 2, the executive branch, which will be just in a few minutes. But we have a couple of things to clean up or finish off on Article 1. So the first one I want to talk about, and this will be really brief, Article 1, Section 9. This is regarding slavery. When the Constitution was adopted, the determination was made that in 1808, automatically the importation of slaves would end. Slavery would still be allowed and slaves could be sold, but you could not import any additional slaves as of 1808. Important, but not much more to explain there. Our next slide, privilege of the writ of habeas corpus. This is pretty critical. The writ of habeas corpus, it's a Latin term that essentially means we have your body. The government has you in custody. When the government has you in custody, certain rights apply. This goes way back to the time of the Magna Carta. When you are in government custody, there are certain issues. The government can't starve you to death. They have to feed you. The government can't make you die of thirst. They have to provide you water. They have to provide you basic health care if you're sick. As long as you're in government custody, habeas corpus says that you will be protected, your rights will be protected, you have the right to trial, to be told what the charges are against you as the reason why you are being held by the government. Now, this section of the Constitution says that the writ of habeas corpus shall not be suspended unless in cases of rebellion or invasion, the public safety may require it. 2 times the writ of habeas corpus has been suspended. The first one was under President Abraham Lincoln. And during the Civil War, he had certain journalists put in prison because they were publishing stories that Lincoln felt made it hard for him to prosecute the war. They hadn't broken any laws. They had a First Amendment right to be critical of the government, so that wasn't the issue, but there was a rebellion going on, and so Abraham Lincoln suspends the writ of habeas corpus. These folks, these journalists were put into prison, were never charged with anything, and the arrangement was as soon as the war was over, they would be released and no charges at all would be filed against them. So that was the first time. The second time it was suspended was right after 9/11. And there were some questions about whether this was a proper use of the suspension, because clearly there was no rebellion. The question is, was there an invasion? And President George W. Bush argued that there was an invasion with the attack on World Trade Center, and that therefore he had the right to suspend the writ of habeas corpus. He did it in a very narrow fashion, which at least that much is to his credit, where he said that it would only apply to non-citizens, since citizens of the United States would not have the writ of habeas corpus suspended. And it would only be suspended against named individuals. So it couldn't even be a broad suspension against Muslims or people from Iraq or any particular country. It would be just naming individuals and saying the writ of habeas corpus is suspended. Now, that is still on the books. It's still permissible, although it hasn't been used in more than a decade. But those are the two times when the writ of habeas corpus has been suspended. We spoke, I think, in the very, very first one of these seminars about the writ of habeas corpus being included in the Articles of Confederation. It is one of only 3 things that were in the Articles of Confederation that remained intact when the new Constitution was written. And we'll have a little more to say about habeas corpus, especially when we get to the amendments. Our next slide, talking about Bill of Attainder or ex post facto. Bill of Attainder is that the government, the king, the president, Congress cannot pass a law that specifically attacks one individual or one family group or some small group. Bill of Attainder was used a lot by the king when he was upset about one of the people in his kingdom. He would have a Bill of Attainder passed that said not only that person loses all their rights, but that person's family loses all their rights. Bills of Attainder are hereby prohibited under this from the federal government issuing them. You'll see that states, in a few minutes, states are also prohibited from issuing a Bill of Attainder. Ex post facto is an important one. Ex post facto, again, a Latin phrase meaning after the fact. And basically it's if a person does something that the government determines is wrong, but there was no law against it at the time that the act was done, the government cannot create a law and then go back and prosecute the person who committed the act, even though it was legal at the time he committed it. So ex post facto laws are not permissible, but ex post facto is still an issue. Most recently, I would say in about the last 15, 20 years, there was an instance where I think ex post facto occurred. So I'm going to leave this up to you to decide. I'm going to use myself just as an example here. Suppose that I was convicted of a very terrible crime like rape. So I've been charged with rape. At the time that I am charged, the maximum punishment is, let's say, 15 years in prison. So I'm charged, I'm convicted. And during that 15 years, let's say 7 or 8 years into my incarceration, the state decides that a 15-year term is not long enough, and they're going to change it to 30 years. Am I now going to have to stay in prison for 30 years, having been convicted of rape, or 15, which was the maximum at the time I was convicted? Short answer there is 15 will be the maximum. But the issue that has come up, same situation, I have been convicted of rape, 15-year sentence. In the middle of my sentence, the state passes a new law saying that there has to be sexual a sexual offender registry, and that anybody that has been convicted of a sexual offense has to register. So now the question is, at the conclusion of my 15-year term, do I need to register, or was this an additional punishment that was added on after my conviction? There's a split of opinion here, but the Supreme Court said that this is more of a paperwork function. It's not really creating an additional punishment on the person who was convicted, and so requiring registration on a sex offender registry does not violate ex post facto. It's been criticized, but at least now you understand what the issue was. Okay, moving on, we have taxes, apportionment of taxes. When the Constitution was put into effect, the Constitution said very clearly right here that taxes are going to be laid in proportion to the census or the population count of a state. In other words, the state was responsible for paying its federal tax to the United States Treasury, and it would be based on population size. There would be no direct tax by the federal government on any individual. This was modified, as you see here, with the 16th Amendment, everybody's favorite amendment, required a constitutional amendment to implement the United States income tax, because that is a direct tax on individuals. And so in order to have it, you had to modify the Constitution. So this section has been superseded by the 16th Amendment on the U.S. federal income tax. No export duties for anything sold by any state, either to another state or to a foreign country. The government can't put a tax on that. You had the situation where before, under the Articles of Confederation, a product might be manufactured in one state and sold in another state, and the second state put a tax on its importation. This is now specifically prohibited, cannot be done in the United States. To the next slide here. No preference shall be given on regulation of commerce or revenue to the ports of one state over those of another. The reason that this has been put in the Constitution was before the before the Constitution, under the Articles of Confederation, there were situations that arose. The most famous one was a dispute between the Port of New York and the Port of New Jersey. If you've ever seen a map of the ports, they are side by side, Port of New York and Port of New Jersey. The state of New York needed to raise revenue, and so they passed a law saying that any ships that docked in their port, those ships had to pay a tax based on the tonnage of the ship to help the state of New York pay for the operation of the port as well as other things. Well, immediately next to it is the Port of New Jersey, which today is actually combined with the Port of New York Authority. But New Jersey said, well, we're not going to charge that tax. So you can imagine ships that were coming to America wouldn't want to dock at the New York piers because they'd have to pay the tax. And so they just waited out in the harbor until a pier opened up in New Jersey so that they could unload there and not pay the tax. That is the reason for this section, which is that no regulation regarding ports of one state and giving them a preference over another state would be allowed. So that's the basic function of this. Now we are into, this one's an important one. No money shall be drawn from the treasury in consequence of an appropriation made by law. A regular statement and account of the receipts and expenditures of all public money shall be published from time to time. So the second clause here creates the budget of the United States, which has to be made public. No appropriation of money by the federal government can be spent unless it is appropriated by Congress. This is the section of the Constitution that opposite Trump, those who were opposed to Trump's border wall, said that he cannot use funds because they were never expressly appropriated by law to build a fence. And that argument is true. The Congress did not approve $6 billion or however much it was for the building of the wall. Trump took money from the Defense Department. Is that a violation of this section of the Constitution? Well, the argument that Trump made, and it's been made by other presidents as well, you can't go running to Congress to get an appropriation to pay for every single item, every time they need to buy a box of paper clips or something like that. So what happens is the various departments of the federal government, including the Defense Department, they're given an annual budget. And there is some degree where the president or the executive branch can reallocate some of the money that's been appropriated to that department, including the defense, or something else that's come up, rather than having to run to Congress for approval on every single item. So the question as to whether what Trump did violates this section of the law, there's an argument on both sides. No title of nobility without, obviously, we don't have kings or dukes or barons or anything like that because the Constitution prohibits that in the United States. But the highlighted section here is the important one. No person holding any office or profit of trust, and that would be including the president, without the consent of the Congress, shall accept any present emolument, office, or title of any kind of any king, prince, or foreign state. This is the emoluments clause that I think is the most important argument against Donald Trump. Emoluments will be mentioned again shortly in Article 2, but here it basically says that a person holding federal office shall not receive any type of an emolument or present from a foreign state. And I guess the question is, when the Trump hotels collect money from a foreign state, is that Donald Trump collecting them because it's his own personal holding company? So is he in violation of the emoluments clause? I believe that this is the stronger argument, but we'll see emoluments mentioned once more. Okay, moving on to our next slide. Now we're Article 1, Section 10. These are acts that states are expressly prohibited from doing. First one, no state shall enter into any treaty, alliance, or confederation with a foreign nation. Under the Articles of Confederation, you remember this was a loose federal government where individual states could make treaties with foreign countries. They could give them preferential trade treaties or other types of preferences that would elevate them above another state. Created problems. So here they fixed it with this one basic statement. No state has the power to enter into a treaty with a foreign government. And then, as we said before, no state has the ability to pass a bill of attainder an ex post facto law. So state governments are prohibited from this just as the federal government is. And also that no state can pass a law that impairs the obligation of contracts. It's principally an issue about slavery. And could a state prohibit the sale of a slave? If it was a sales contract, no state government could pass any law impairing the obligation of that. Imposed duty is not important, so let us move on to okay, what you are about to see here, states prohibited from the exercise of certain powers. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops, it would be like a militia, or ships of war in time of peace, unless the consent of Congress is received. So prior to the Constitution, under the Articles of Confederation, each individual state was allowed to have its own militia. And there were problems related to that. If they were called into service of the national government, they had these militia were trained differently, they were armed differently. The leading officers of the militia oftentimes gave their allegiance to their state rather than to the national government. So what was said here is that no states shall be able to keep troops or ships of war. That created some disturbance among the states trying to ratify this Constitution. And it required the addition of the Second Amendment, the right to bear arms, to solve this impasse so that they could get it ratified. So this right here is the impetus of the Second Amendment regarding the right to bear arms. When we get to it, you'll see it's primarily a regulation of militia and not individuals. We'll talk in great detail about that. The short answer is there an individual's right to own a gun? The answer is most likely yes, but it's not necessarily from the Second Amendment. It comes from the 10th Amendment. When we get to the amendments, we will discuss this further. Okay, we are now into Article 2. We are done with Congress, and it's important to note if you printed out a copy of this as we're going along, you will see that the Article 1 of the Constitution, the creation of the legislative branch, is by far the longest section of the Constitution. And it is clear that it was considered the most important article of the Constitution. Legislative branch was supposed to really be the preeminent power of the federal government. But they recognized the need for an executive branch, and we're now going to go into discussing the executive branch. That's Article 2 of the Constitution. The first section of this is just a nuts and bolts, who can become a president. So who can become a president? Executive power is vested in a president who holds office for a period of 4 years, and together with the vice president is chosen as follows. We're about to get into the Electoral College, which is a mess. But let's briefly do a recap here. President's term is 4 years. A member of the House of Representatives, their term is 2 years. A member of the United States Senate, their term is 6 years. We spoke about this once before, the staggering of terms. This is very important because in the original government of the United States, under the Articles of Confederation, terms were 1 year. And If the public decided that they were unhappy with the way the government was being run, and they essentially at an election fired the current government and hired a new government for a period of a year, how long would it take these newcomers to even figure out how to run the government, what its function is, the processes that are involved? In other words, there was no continuity of government. This creates a continuity of government. No matter um, no matter the term, there's always going to be a group of people in government that have been there before that can take the new people by hand and say, okay, this is the way we do things. So the staggering of terms was critical. It is actually, I'm going to argue, the reason why the United States, at least up until now, has never had a situation with an election of somebody like Adolf Hitler and the Nazi Party. And really briefly, what happened at the conclusion of World War I was that Germany was told, you have to adopt a democratic form of government. You have to get rid of your Kaiser, essentially an emperor or a king, and go with a democratic form of government. So the Germans, being typically German, they said, well, first let's take a look at what's considered a good democracy. We'll use that as a model. And so they took a look at the United States Constitution, things that we just talked about. And typical of Germans, they said, okay, now how can we make it better? And they saw this 4-year term for a president and a 6-year term for a senator, and even the 2-year term for a member of the House of Representatives. And they said, what happens if we make a mistake and we elect a complete idiot to the office? Let's say, of the United States Senate. Are we really stuck with him for 6 years as soon as we realize we made a mistake? So they said, that probably defeats the purpose of democracy. We can do better. Let's have elections with shorter terms of office. And this is pretty much how the Nazi Party came to power. They were never a majority power, but they still managed to win enough elections. And since almost any party can stay popular for a year or two, no party stays popular for a decade. So what happened in Germany was, as soon as the Nazi Party was elected to enough positions in a short period of time when they were still popular, they then said, well, we don't have any need for future elections, and so they banned future elections. This is why the staggering of terms is, I think, so important here in the United States. Okay, let's go to the mess that's known as the Electoral College. I'm not going to read this because, number one, it is confusing. Number two is that within 8 years of the passage or the ratification of the Constitution, they discovered a major flaw in the Electoral College, and that was in the election of 1800, when Thomas Jefferson was elected president. He was the founder of the Democratic Republican Party, which is sort of a forerunner of the Democratic Party today. But according to the rules of the Electoral College in place, the vice president would be the person who got the second most Electoral College votes, which was Aaron Burr, who was a member of the Federalist Party. He was on the opposite side. And the determination was made, this isn't going to be very effective when the president is of one party and the vice president is of the opposing party. And so very quickly after the election of 1800, the 12th Amendment was adopted, which changed that. So they took an article that was a mess, they amended it, and the amendment actually made it worse. The 12th Amendment made it worse. So then they decided, well, we needed to amend it again. So it's the only section of the Constitution that has been amended twice. Amended again by the 23rd Amendment to try and fix the mess of the Electoral College. And it made it even worse. So I guess the only thing I want to discuss here is what was the purpose of the Electoral College in the first place? Why not just a national election, and the winner of the national election would win the office of president? So when the determination was made in basically under the Articles of Confederation, the United States was going to operate as a form of democracy. In other words, the people make the choice. The problem was that all of the great political philosophers, going back to Socrates, Plato, Aristotle, even before that, they understood what democracy was, which was direct representation of the people. And they said that relies on something that is very critical. For the people to be able to vote and make these decisions, they need to be educated. They need to be educated in the issues at hand. And the concern was, what if they were not well enough educated? What if they would make a mistake? I guess the argument would be that Trump would be an example of that. So the decision was made that we'll have a modified form of democracy. The people will vote in their individual states, and those results will be tabulated in the individual states. And based on those votes in a state, the state legislature would appoint what are called electors to vote on or to cast the electoral votes in favor of the candidate that the state legislature has said won the election in their state. This was an opportunity because the electors at that time were not required to necessarily vote the way the population of the state voted. So it was an ability to correct if in the minds of the state legislature, basically the elite politicians, that if the people made a mistake, they can overturn it. That was the purpose of the Electoral College. Its need today, I guess people can still argue that its need is still there because are the people sufficiently educated in the issues of their country to select the right person to preside, to be president? Most of the states, I think all but one of the states, have adopted the position that the electors from that state have to follow the vote of the people of the state. Many states say that if one candidate wins in the state, even if it's by a very slim margin, that all of the electoral votes of that state are to be cast for that candidate. Other states have a proportional system where if one candidate got 52% of the votes and the other candidate got 48% of the votes, 52% of the electoral votes from that state would go for the first candidate and 48% to the other candidate. So that's proportional, the use of proportionality in the Electoral College. But regardless, we all know the Electoral College is not well liked, and probably it's time for repeal has come. The only problem is repealing something in the Constitution is not an easy function. So I think we're going to be stuck with it at least for the near term. Okay, now We've determined how a president is selected. It's through the voting process and then the electoral college. Now let's talk about who could be a president. And you'll see that also in this section, no actual power has yet been given to the president. It's how we select them, and now it's who is going to be, who can be a president. So the first requirement is you need to be a natural born citizen or a citizen of the United States at the time of the adoption of this Constitution. The reason they had to put that second clause in, simple example, we all know George Washington was our first president. He took office in 1789. He was born in the 1750s. Was he born, is he a natural born citizen of the United States when the United States didn't exist in the 1750s? Technically didn't exist until 1776. So would he be considered a natural born citizen of the United States? No, because the United States didn't even exist. And as a matter of fact, the first 8 presidents were all born before the United States became its own country. So that's why they had to put the clause in here. You either need to be a natural born citizen or a citizen of the United States at the time of the adoption of the Constitution. Now, there's a lot of controversy about what a natural born citizen means. Most recently, we had Ted Cruz, not too long ago, in the last election cycle, who was wanted to run for president of the United States. Ted Cruz's father was Cuban. Ted Cruz's mother was American, and Ted Cruz was born in Canada. So an argument was raised, he's not eligible to be president of the United States. He's not a natural born citizen. If you look at this language from a purely technical use of the words, he probably is not a natural born citizen. But over time, the courts have ruled that the child of a female American citizen gets the citizenship of the mother. So Ted Cruz's mother was a United States citizen. He's a United States citizen, and he's natural born, even though he wasn't born in the United States. John McCain was another example. This one was not controversial really at all. Military bases and embassies overseas. If you are born on an American military base or in an American embassy overseas, those locations are considered actually on American soil. So you are a natural born citizen. Anyway, so we have this this issue of natural born citizenship. I think we've kind of covered the issues there. The second thing that we need to talk about is the age of a president. You have to be a minimum of 35 years old. Still awfully young. So question, I guess, is who was, this is a trivia question, who was the youngest president ever? There are 2 possible answers. Theodore Roosevelt became president after the death of President McKinley. At the time that he took office, he was, I believe, 42 years old. That would make him the youngest person to assume the office of president. John Kennedy was the youngest person actually elected president of the United States. I believe he was 46. After Theodore Roosevelt completed his first term, which was basically the completion of McKinley's term, he then ran for the office himself and won, but at that point he was actually older than John Kennedy was when he was elected. So who was the youngest president? I would say Theodore Roosevelt, who was the youngest elected president. That would have been John Kennedy. And you need to be a resident for 14 years within the United States. So you're a natural born citizen. What's this residency? Well, when they drafted this, there was a pretty clear understanding George Washington was going to be the first president. But the second president and the third president, everybody kind of suspected it was going to be between John Adams and Thomas Jefferson. The problem was that at the adoption of this Constitution, John Adams, who had been born in what would become the United States, was made ambassador to England. And Thomas Jefferson was made ambassador to France. And they spent a considerable period of time there. So the reason they put this in was the concern. What if Thomas Jefferson comes back after serving as ambassador in France for a number of years? He probably understands the issues of France pretty well, but he hasn't been in the United States for a while. He better be here for at least 14 years to know what the real issues are in the United States in order to become president. So that's why they put the 14-year residency. Moving on. This, you will see, this section, again, no power conferred to the president here, just the nuts and bolts. What happens if a president is removed from office through impeachment? What if he dies? What if he resigns? What if he becomes seriously ill and can't do the job? What happens then? It says here that the duties of the office of president shall devolve on the vice president. Does that make the vice president president? And the short answer is no. The vice president remains vice president. He is just acting on behalf of or acting in place of a president because that position is vacant. Lyndon Johnson was not very happy with that when he took office after the assassination of Kennedy. And he was told that technically he's still vice president. He didn't like that. So the 25th Amendment was passed shortly afterwards, which makes the determination that when a vice president assumes the duties of the president, he is now president. He's not the vice president assuming the duties of the presidency. He becomes the president. Now, there is a Presidential Succession Act. So I think we all know that if a president becomes incapacitated or resigns or dies, that the vice president now becomes president. But what if the vice president cannot serve as president? He's also incapacitated. Let's say the two of them are killed in a joint accident. So then the Speaker of the House becomes president. Now here's an interesting problem that one of the many small but interesting flaws in the Constitution. Become a member of Congress and to become Speaker of the House, you do not need to be a natural born citizen. You can be a naturalized citizen. So what happens if the first two positions, president and vice president, are incapacitated in some way? Speaker of the House is third in line, and let's say the Speaker of the House was foreign-born. Does that person take the office of president? The answer is no. It's as if it's still vacant, and then they go to the president pro tem of the Senate, who also does not need to be a natural-born citizen. So it still might be vacant. So what's happened, especially since 9/11, when they recognized that big catastrophe, one nuclear bomb set off in Washington, and take out a lot of people in the government, they passed the new version of the Presidential Succession Act, which carries it out to, I believe, 35 places. So the first 34 positions die or become incapacitated, the 35th becomes president. Hopefully we will never have to experience that. Okay. The next one, again, no power conferred here. The president shall receive compensation for his services. It shall not be increased or diminished during the time for which he was elected. Incidentally, the same applies to the members of Congress, and the same applies to the members of the judiciary. So no person elected to office can have their compensation reduced. You've probably heard people saying, these folks in Congress shouldn't get paid because they're not doing anything. The president shouldn't get paid. It basically makes it very clear here, these people will get paid. You can't argue that they're not doing their job, so they shouldn't get paid. And then you remember we spoke a few moments ago about the emoluments clause. It's mentioned here again. The president shall not receive within that period any other emolument from the United States or from any other, from any individual state. So this is really not the issue about President Trump and Trump hotels, because this is emoluments from within the United States. So is that previous one, Article 1, Section 9, that is the emoluments clause that really matters. Last part of Section 1, and again, still no powers conferred to the president. Before he enters on the execution of his office, he has to take an oath. And the oath is that he will faithfully execute the office of the President of the United States and will, to the best of his ability, preserve, protect, and defend the Constitution of the United States. Now, what happens if a president is elected to office and there is a law on the books that the president doesn't like? I'm going to use, let's say, the Environmental Protection Agency Act as an example. So let's say I'm really a right-wing pro-business person. I get elected to be president. I have this Environmental Protection Act that I think goes too far and regulates business too much. It is the law at the time that I am sworn in. Am I going to faithfully execute a law that I don't believe in? And if I don't faithfully execute it, and how do you define faithful execution? If I don't faithfully execute it, I violated my oath. Is that sufficient for impeachment? The second clause of import in the oath: to the best of my ability, I will preserve, protect, and defend the Constitution of the United States. The conjunctive clause, preserve, protect, and defend the Constitution, means you are obligated to do all three. So let's take the example of Abraham Lincoln, who, among other things, suspended the writ of habeas corpus. He knew that that was controversial and could be considered unconstitutional because he didn't technically declare the Civil War a war. It was just an insurrection. If you have the right to suspend habeas corpus, well, he said he does have that right under this presidential oath, where he says, in order to preserve and protect the Constitution, I choose not to defend a particular passage of the Constitution. So this raises, again, an issue that is unresolved. Do you have to do all three? And how faithful do you have to execute these things? All right, now we get to Section 2. This is the beginning, and it's a very short section, of the official powers of the president of the United States. So let's take a look at them one at a time. The President shall be Commander-in-Chief of the Army and Navy and of the militia when called in actual service of the United States. So the Commander-in-Chief clause. You now need to think back to Article 1, Section 8, the enumerated or express powers, the war powers given to Congress. Those powers are very broad and they are exclusive to Congress. So what does Commander-in-Chief mean? It's what's the residual after everything else under Article 1, Section 8 is taken out because that belongs to Congress. It's the residual that the President has. And the reason for appointing a Commander-in-Chief again stems from, well, the best example comes from earlier, but the best example is during the Civil War. Congress wanted to exert its power, its war powers, and basically hold hearings and question generals and try and formulate its own war policy, its own military plans, and that clearly was not going to work. So what happens is Congress says, okay, the President will speak on behalf of Congress and order the military to do the things that Congress says it needs to do. That is the intent of Commander-in-Chief, that he is the spokesperson on military affairs of Congress so that one voice is heard and not a committee. Okay, so if there's power in the presidency, it's in this section of Commander-in-Chief because he is the voice that speaks to the military. The very next clause shows you not much power here. The President may require the opinion in writing of the principal officer in each of the executive departments. Principally, we're talking now about the cabinet. And so the President has the ability to require cabinet members to give him in writing their opinion about an issue. He doesn't have to follow that opinion. He's just got the power to order them to write that opinion. Is that much of a power? Not really. And then the third clause here, the President shall have the power to grant reprieves and pardons for offenses against the United States. This is a little bit of power, but always keep in mind, most pardon has to be for a criminal act, and most crimes are state crimes. The President doesn't have authority to issue a pardon for the violation of a state crime, only the ability to pardon for a violation of a federal crime. And there aren't nearly as many of those as there are state crimes. So, as Commander-in-Chief, that's some power. He can make his cabinet officers give him their opinion in writing about an issue, not much of a power. He has the ability to grant pardons, but only under limited circumstances. So there's not a huge amount of power here. The next article, or the next clause, is regarding treaties. The President shall have the power, by and with the advice and consent of the Senate, to make treaties, to nominate people to federal office, to appoint ambassadors, judges, and other officers of the United States, all of which require the advice and consent of the Senate. Who really has the treaty-making power? Is it the President, who does the negotiation, presents a treaty to the Senate, and the Senate has to approve it by a 2/3 vote? Or is the real power in the Senate, who is the one who enacts the treaty? All the President does is the grunt work. Congress, or the Senate, is the one who makes those treaties. And that requires a 2/3 vote. Now, he shall nominate ambassadors, other public ministers, judges of the Supreme Court. This does not require a 2/3 vote. This only requires a simple majority. But still, to fill a position on the Supreme Court or to appoint ambassador, it is up to the Senate to do that. President can only nominate, doesn't have any power beyond that. Now, the inferior officers, Congress may by law vest the appointment of such inferior officers as they think proper in the president alone. This is why President Trump is less likely to nominate somebody for a cabinet position and is more likely to elevate somebody to an acting cabinet position, because that he can do without senatorial approval. So this is by law. This is not a constitutional issue. Congress can change the law and determine what inferior officers that the president can appoint. They could, and they probably should make that strict. Another power that the president has, which is not a huge power, has the power to fill up vacancies that occur during the recess of the Senate. If the Senate is in recess and an ambassador to, let's say, the United Nations dies, the president can appoint somebody to be the ambassador who will fill out or hold that position until the end of the Senate term. So he has the ability to make recess appointments. Fortunately, the Senate has taken precautions to make sure that they are never in recess more than 3 days to prevent the president from making such recess appointments. Okay, we've talked about the powers of the president, which aren't much. He's commander-in-chief. He can nominate people to high office. He can negotiate treaties and need the Senate's approval to do them. So he doesn't really have a lot of power, but he does have duties. Even these are kind of a joke. The first duty the president has, constitutionally mandated, shall from time to time give to Congress information of the state of the Union. He is required to give a speech to Congress. And in that speech, he is to recommend to their consideration such measures as he shall judge necessary and expedient. In other words, his speech can say, this country would be much better if you adopt these laws. I'm suggesting. But I can't do it alone. You have to pass them. I'm just suggesting them. That's the power. That's his duty, is to make suggestions and nothing further than that. The next clause, he may receive ambassadors and other public ministers. He can go to the airport when the Prime Minister of Canada comes to visit and welcome him to the United States. Big deal. And he shall commission all the officers of the United States. That would be everything that doesn't require Senate approval. So those are his duties. Big deal. And now we get to what if he screws up? President, Vice President, and all civil officers of the United States shall be removed on impeachment for and conviction of treason, bribery, or other offenses. So I don't know. I think the most important thing to talk about here is civil officers in the United States can be removed by impeachment. So it's not just presidents that impeachment is involved in. We talked about this in Article 1. It's members of the cabinet, the vice president, um, other folks that are put into office, such as judges. And in actuality, judges are the most likely, federal judges are most likely to be impeached, and usually for two reasons. One is that they have taken a bribe in a case. If Congress finds out about that, they are very likely to be impeached. A number of judges over 200 years have been impeached for that. And the other one, which we'll see when we get to Article 3, which is coming up in our next session, but judges are appointed for life. They serve for life. What happens if a judge takes this too literally and is in his 80s or 90s and has become incompetent, has dementia, or just completely unable to do the job? Judges can be impeached for that. Those are basically the two reasons for judges to be impeached. And there have been a number of impeachments. I think there have been close to 100 judges impeached over American history. As you know, no president or vice president has been removed from office through impeachment. And I think that there might have been one or two, I'd have to double check this, cabinet members who have been impeached. So with that, I think we have completed Article 2. I just want you to consider the fact that it's clear from this document that the President of the United States was never meant to be very, very powerful. He doesn't have a lot of power. Most of the power was meant to belong to the legislative branch. But since we're out of time, we will hold this for our next session and briefly discuss, before we get into the judiciary, how it is that the president did become more powerful than was ever intended. And with that, I wish you all a good rest of the afternoon, and we will see you next week.
Mm-hmm.